Back on Morning Line, our guest with us on the final segment here is Clint Kelly, malpractice attorney. Earlier in the program, you talked a little bit about COVID cases and malpractice and how there's a law that was passed in the state that, kind of means you can't really sue for COVID malpractice, whatever that may be. But before that was passed, we know there were some nursing home facilities that had some real issues, of which I think you're involved in some litigation there. I just kind of wanted to get from you where we kind of stand on that and how things look moving forward there.
Well, right now we've got 5 cases of 26 that are filed that are proceeding ahead, and we hope to have a trial date in the first one sometime early next year. We tried to negotiate with the company, actually the insurance company for the nursing home, and those negotiations failed. So, and it's not unusual. It's early. Sometimes you're on the insurance company's timeline when it comes to whether you settle a case. So that's why we're proceeding like we are. The thing about those cases that are distinguishable from other nursing homes is the Gallatin Nursing Home had more positive COVID cases among their residents and their staff than the rest of the nursing homes in Tennessee combined.
Okay.
Think about that, Nick. And so you ask them, and this is what I asked the judge, and ultimately I'll ask the jury if it comes to that, why?
Right.
Why were the other nursing homes in Tennessee able to avoid a massive outbreak or no outbreak at all, and you got brought to your knees and had to evacuate patients to the Summer Regional Medical Center and get shut down? The reason was they weren't wearing masks, they weren't wearing protective gear, they weren't screening as per their protocol, so they were letting people who were sick deliver care that they shouldn't have.
So what on earth is their defense going to be?
That people could get into the nursing home who were asymptomatic but were still sick and had contact with the residents.
The whole problem with any argument they give you is that same rule, if you buy that, would apply to every other nursing home in the state. That could happen, and yet it didn't in these other facilities, and it did in yours. So that doesn't wash it. So what other reasons could there be for their defense?
Well, that's basically it. I mean,
well, that's not
you
going
hit
to work.
The nail on the head. How are these asymptomatic?
If I'm on the jury, I'm like, really? Well, why is it not happening over here?
Well, I'm just telling you that's what it is. Or they'll say there's no guarantee that the masks and the gowns and the gloves and the protective gear would have prevented the infection, which of course goes right back to your point. Well, how did it prevent infection in all the other nursing homes in Tennessee?
Right.
Why are you the unlucky one? Why are you the cursed one?
Okay, so how do these things play out? It does take time, doesn't it?
It does.
These cases, and it was before the law passed,
Right, we got grandfathered in.
Okay.
On purpose.
Yeah.
On purpose. Legislature, I mean, and that's a testament to the power of emails and phone calls to your representatives. They raised such a stink that the legislature built in a grandfather provision for them so that they were allowed to go forward in their cases.
Well, the problem is if it turns out that the facility was negligent, and let's just say there was another one that, happened after the law was passed. That's why that law is not a good law. These other facilities will be protected, would they not now?
They are, yes.
Well, how's that a good plan?
Well, we can debate the merits of that till we're blue in the face. The fact of the matter is the COVID immunity law is there. It's going to remain there. It continues to get renewed. The problem with the COVID immunity bill that I have with it, put aside whether or not you should be able to sue someone because they got COVID and they weren't treated appropriately for the COVID. What happens if you are in for treatment of COVID and a hospital makes a horrible mistake, and in relationship to that, you lose your leg and it has nothing to do with COVID?
Right.
Maybe you get a blood clot because you've been laying in the bed too long and they didn't apply proper what we call anti-blood clot medicine, and you lose your leg. The hospital's going to come in and say, look, we were treating COVID and this is related to the treatment because we had to keep you in the bed on a ventilator, therefore we're immune from liability. Is that fair? Because COVID didn't cause you to lose your leg. What caused you to lose your leg was because you didn't get proper blood clot anti-prophylactic drugs.
Yep.
That's the problem I have with the law.
I gotcha. I'm just wondering how many patients maybe ended up getting burned by that. I mean, I guess you would never hear about it. I don't know if you've had cases you've had to turn down.
I've had to turn down cases
because of that. You're like, you have a case here, but this law protects the hospital.
And I'm not talking about ones where the COVID was mismanaged. I'm talking about ones who had collateral damage.
Yeah.
That's what we call it.
Yes.
Unrelated to the COVID, but it couldn't bring the claim because the COVID immunity law is so broad that it covers treatment of the patient that's related to COVID, so the collateral damage falls under that blanket of immunity.
It's a little nuance in all of this stuff. That's why you really have to think through these laws before they pass, and unfortunately that doesn't always happen. So as we kind of wrap things up here, just wanted to get from you, I mean, are there any other cases? I'm just curious when you come on, what's happening right now these days? Anything much changing as we come out of COVID? Are there other issues that maybe you're handling? Any class actions or along those lines? Are there any interesting cases you've had come across your desk of late?
Yeah, we're starting to get more what we call birth trauma cases. These are cases where a baby is born and severely injured. And there are a variety of different reasons for that. It could be because the baby wasn't delivered properly, should have been a C-section. We have a case right now pending in Chattanooga where a baby had what's called a meningocele. That is a if you will, like a bump on the spinal cord where the nerves aren't developing properly. It was detected by fetal ultrasound at the 3-month mark. And what you do when you find that is you've got surgeons at Vanderbilt who can actually go inside the womb and repair that anomaly while pregnant. Okay. So when the baby's born normally without any damage. Well, in this case, the doctor misread the ultrasound. It was there plain as day.
I mean, pretty obvious. Not one of these things like, oh, you can see how you miss it.
You would have been able to tell.
So, what's that? Okay.
Exactly. You would have been able to tell it was an anomaly. I wondered.
Well, he didn't even look at it.
Probably not.
Yeah.
It was a she, and she probably didn't look at it. Baby's born with this anomaly, and of course the baby's born vaginally, so there's compression on this knot as the child's coming out, and so the child sustained additional damage, and now the child's probably going to require a walker the rest of his life. He's only 3 years old right now. We're seeing more of those types of cases. I can't explain why, but we handle those cases because when you've got a child that's injured, you're talking about a lifetime of care.
No, so it can be a very large type of settlement.
Sure. I mean, you've got a kid that may not work, may need round-the-clock care the rest of his or her life. Those are very expensive situations, and there's only so much the government will provide in disability. I mean, you just heard Linda call about what you have to have just to have Medicare coverage. You'd be amazed what you have to have disability coverage in the healthcare arena. So we have to create what's called life care plans, fund them with enough money so that these injured children, or babies, can be cared for the rest of their lives.
So that it was not standard of care, because if he had noticed it, there was an appropriate solution that could have avoided
Yes, a surgical treatment. Done at Vanderbilt, at the Children's Hospital.
So experts will see this, and you'll, I'm sure, call experts if it goes to trial who can say, look, it's obvious that's there. This would have been the obvious solution. Had they followed the standard of care, this child would have been born normal, no problem, and they missed it, and this child's facing a walker the rest of his life.
They're the most high-risk cases for me and the most important because I'm not only representing an injured child, I'm representing the parents as well. So everybody's fate is depending on how well I'm able to pursue that case and get a recovery, whether it's settlement, and most of them do settle, or whether we go to trial. Because if I get enough money so that child's taken care of the rest of his life or her life, I can go to bed at night and feel good.
What kind of number would you talk about?
Millions.
Yeah, I mean, you just have to, I mean, this is an infant, the rest of the life. I mean, he or she may not, is it a little boy, little girl, I don't know.
A boy.
May never be able to work.
Yeah,
I mean, who knows? I don't know.
It's 8 figures. Because that's what it's going to cost to take care of this kid, and also the lost earning capacity, because the parents made really good money. These were very educated people who were making $500,000–600,000 a year. Imagine what that child would have earned going to private schools, getting a degree or postgraduate degree and earning money, and now instead, because this kid has mental and physical challenges, this child may be lucky to work behind a counter at a grocery store.
What was the you know, in dealing with the parents, how do the parents deal with something like this? They did not know either when it was done, first that ultrasound was taken or whatever. They didn't know it either. They didn't find out till after the child was born?
No.
And they're like, what?
In fact, they didn't find out for a year.
How did they find out that it had been detected earlier but missed?
They went to another hospital, and the other hospital staff told them, did you know that this was there?
How did the other hospital staff, they just knew that?
Child got into a spina bifida program, and the spina bifida staff said, you understand this was a problem during pregnancy.
Because they had all the medical records.
Correct. And also she didn't know that there was a treatment available. It's called fetal meningocele repair surgery, where they can go in there and do this in utero, deliver the child by C-section when the child goes to term, and the vast majority of the time the child's born without any neurological difficulties at all. In other words, she's being told this was preventable.
Yeah, and that's the crazy thing. If not for them putting the child in a program like this and someone there just happening to mention it, they would never know. Do you believe the hospital that made the mistake knew that?
Oh, I'm sure they did. I don't know the doctor did.
The doctor did, you think? I thought the doctor missed it.
It was an obstetrician, and she knew it. She didn't say a word. Not a word.
Yeah, no, okay.
Because when the child was delivered, and by the way, it was delivered by a different obstetrician because the one that was handling the prenatal care and doing the ultrasound, she wasn't there that day. She found out after the fact that the child had been born with this meningocele.
And they must have said, hey, look, there's a meningocele. That would have shown up when you looked at prior.
She went back and looked at the ultrasound and realized she missed it.
And she
didn't say a word.
Didn't say a word.
Nope.
And so this, I wonder how many times things like this may happen. If that other hospital, the family wasn't looking for it, but that other hospital saw it and said, by the way, and the mother and dad must be saying,
Nick,
wait, what did you say? Well, yeah, this would have been something we're aware of, and there was a procedure that could have prevented all this.
This happens most of the time, is these situations are not revealed to the patients.
Okay, I guess that makes sense. And that's why
that's how you avoid lawsuits.
If you have something unusual like that, that's an example. And these parents, as you said, educated with means, but they didn't know to be looking for anything. It just happened that they had the child in this program, and someone, would you say it was a year later?
Almost a year, yeah.
Oh, so was
But the statute of limitations is a problem because the a child under the age of 18, the statute of limitations doesn't run on the child.
Okay.
So we call it tolled.
Okay, I guess I didn't know that. So if it's under 18, there isn't a statute like it is for a lot of these adult cases.
And plus, you'd have the discovery rule. Remember, we said 1 year from the date of discovery. She didn't discover it until the staff in the spina bifida program told them. Basically, you realize this happened during pregnancy. It was missed on ultrasound.
Okay, and this, you said it's early in the stage, but are they gonna,
it's probably going to settle because it's so obvious. But we're at the point now where we're going to be taking depositions, and I think the big issue in this case is going to be the medical testimony about what this child's needs are going to be for the rest of his life.
That's where the debate is. There's no debate really that, okay, this was missed, it was a problem that could have been prevented, we're liable for it, it's just how much are we going to pay?
Correct. Oftentimes these cases come down to a situation where I say, look, this case is worth $15 million. The insurance company for the doctor says, no, we think it's worth $2. And in between those numbers is where we try to negotiate out an amount that we both can live with, and usually we do.
Okay, usually you do. And what will happen is you'll come to some negotiated amount, you bring it back to your clients, the parents, and you'll tell them what it is, and they'll make the call based on your recommendation, either that's enough, we'll take it, or no, we're going to go to trial.
Right.
You have the trial threat going up. You're going to win at trial, but you don't know how much a jury will give you.
You say you're going to win. Juries can do anything, Nick. We learned that in the Johnny Depp case.
Right.
But there are probabilities. And we say based on the probabilities, the odds of victory are high. Therefore, we negotiate on that basis. And by the way, these things are done at mediation. That's where the cases nowadays are resolved. We go to a mediator. Sometimes there are 2 mediations. The first one, you position yourself in terms of where the numbers are. The second one's where you actually find a way to bridge the gap. And more often than not, you do.
Fascinating stuff. I love that behind the closed doors, how these work. Clint, thanks for coming on today.
It's a pleasure to be here again.
It's always good talking to you. Again, Clint, of course, here in Middle Tennessee in Hendersonville. Stick around when we get back. I'll be throwing up his contact information. Remember, it's always just nothing to call if you have a suspicion.
Absolutely free.
Do so. Free call, and they'll let you know if you have a case. Clint, we'll see you again in a month.
Thank you.
Take a break. Be back with his number right after this.